Welcome to another episode of Use Your Power. Use Your Power is brought to you by Rev Up, which stands for Register, Educate, and Vote. Use Your Power. I'm your host, Julie Espinoza, Assistant Director at Reach of Plano Center for Independent Living, and I'm visually describing myself as a middle-aged white female with brown hair, and in the background, I have a fall-autumn picture on the wall with orange leaves and my crutches, and they have pink crocheted crutch covers by my mom, Jane. Today, we have two guests from Disability Rights of Texas who are going to explain to us more details about Senate Bill 1, a law that was just recently signed. First, we have Jeff Miller, who is the policy specialist with Disability Rights Texas, and he's going to give us more details about how Senate Bill 1 affects our disability vote. Welcome back to the show, Jeff.
Thanks, Julie. Senate Bill 1 is quite a thing. I am a middle-aged male, wear glasses, have very short white hair and a short beard and mustache. And I'm sitting in a blurry office with bookcases in the background. First of all, just in terms of background, Senate Bill 1 has been in the works in the Texas legislature since January. It started its life as House Bill 6 and Senate Bill 7. And over the course of time, we ended up with Senate Bill 1 that was passed out of the second special session and signed by the governor. And it does impact the rights of voters with disabilities in several ways, which we'll get to in just a second. But just a couple of things real quick about Senate Bill 1. First of all, the bill is over 100 pages long. So there's lots of provisions in Senate Bill 1 that impact lots of things that have to do with voting. And of course, whatever impacts voters with disabilities. So there's lots of things that will be different or might impact us as voters, but if it's not disability specific, I'm not going to mention it per se right now. The other thing is there are some provisions in this bill that really do concern us, but I will say that with a lot of hard work by a lot of people over the last 8 months or so, the bill is much different as it was signed and the way it is now than when it started. Several provisions that potentially could really have been more impactful to voters with disabilities were changed or removed over time. So kudos to the disability community for standing up and making a difference. So let's just talk about some of the things that are in the bill. First of all, when looking at voting by mail in the application process, Senate Bill 1 specifically now says that when a voter fills out an application for a ballot by mail, their signature on that application must be an ink on paper signature or a wet signature, as it's sometimes described. The issue with this is that would preclude someone that's unable to sign the ballot because of a disability for whatever reason from doing this alone. Now, there is a provision in the law that says that I can have a witness this for me if I can't sign it, but that means that I can't fill out this application independently or privately, that I have to have somebody else involved. And that's concerning to us. Another thing that has changed that isn't specifically disability specific, which is a strange sentence, sorry about that, but voter ID has been around for a long time for in-person voting. There is now a voter ID provision that will be required for mail-in ballots. Something that a lot of people with disabilities do is vote by mail. In the past, that hasn't been an issue. What's going to be required now is that an individual will have to fill out on the application for a mail-in ballot either the last 4 digits of their driver's license number, the last 4 digits of their Texas ID, or their last 4 digits of their Texas voter ID. Those need to go onto the application before it's sent in. If someone doesn't have any of those IDs, then they can use the last 4 digits of their social security number. If someone doesn't have any of those, then they can sign a statement to that effect, and it shouldn't impact their ability to get a ballot by mail. But we are trying to make everybody aware of this, since it was something that voters with disabilities didn't have to do before. This will be different and something that needs to be paid attention to, because there's also a provision that now says, after I fill out my application and I send it in and I get my ballot back, when I vote that actual ballot by mail, I have to put down those numbers again. And the numbers I use when I send in my ballot have to match the numbers on my application. If they don't, that is grounds to reject my ballot. So it's important that people are aware that that's going to be a change. Along with that, there's also a provision that was added to the bill, well, a separate bill, but there's now a provision that the state will create an online portal of sorts to allow people to track their mail-in ballots. So after I apply for a ballot by mail, I should be able to track on this state tracker where that request is, if it's been received by the county, if they've sent my ballot back, and I should know in the process where things are. If there is a situation where the numbers don't match on my ballot and my application, there should be an opportunity to fix that using this online portal. Similarly, if after I send in my mail-in ballot, there is a problem with the numbers or my signatures, or that it's incomplete, or another problem with my ballot, there's now a provision in the law that says that the county has the opportunity to allow me to fix that, so that I know that my ballot will still count if there's a problem. So if the county believes that by the time that the problem is discovered, there's time to fix it by mailing the ballot back to you and allowing you to correct it and send in your ballot again, they have to do that. If they believe there's not enough time to send it to you by mail, the county can call or email you and give you an opportunity to come to the election office and fix that ballot. One of the other big areas that we had concerns about SB1 has to do with the way that voters with disabilities can receive assistance from others in order to participate in the voting process. We know that under federal law, if I have a disability and I need someone to assist me, I have a right to ask anybody I want other than my employer or my union representative to assist me in whatever manner I need in order to access the voting process. So there's been some changes in Texas law in relationship to the kinds of assistance that I can receive and who can do that. One of the issues is that the definition of assistance was changed in a limiting way. The law now says specifically that I have a right to have someone read the ballot to me, or direct me to read the ballot, or mark the ballot for me, or direct me to mark the ballot. But that's the extent of assistance I can receive. We are really concerned about that because under federal law, people have a right to much more assistance and more types of assistance. There's also a change in the information that an assister now has to provide to the county when they go to the polls. They have to give their name and address, of course, but now they also have to state their relationship to the voter and state whether or not they received compensation to assist the voter to vote. Additionally, in the oath that someone takes when they assist someone, which has been around previously, added to that was specifically a provision that says that that oath is made under penalty of perjury. So if someone signs the oath and then disobeys it, they could be prosecuted for that. And it also specifically limits the kinds of assistance that someone can receive in the oath. I have to promise that I will only provide certain kinds of assistance, which is also a big problem, we believe, if people are supporting someone who needs other kinds of assistance that are appropriate under federal law, but now won't be available under state law. In the original versions of SB1, there were lots of ways that curbside voting were impacted. Most of those were removed, but the law now does say that if I give more than 7 people unrelated to me a ride to the polls to curbside vote, that I have to fill out a separate form giving my name and address and stating whether or not I just drove people to the polls or if I acted as an assistant to them. In terms of mail-in ballots, again, and assistance, there's now a provision that specifically makes it illegal to receive compensation to assist somebody to vote. And we were very concerned about that because we all know that some people have personal assistants or other folks that as part of their jobs help them vote. So there was an amendment that was added that says that this prohibition about receiving compensation to help people to register or vote does not apply if you were someone's personal assistant or a caregiver. So that was a good thing. One of the other concerns that we have in general about the bill is that many of the penalties for violations of the elections code were increased, most to a state jail felony. And these are specifically things that apply to people that provide assistance or people that forget to fill out forms in certain ways. And we're concerned about the chilling effect that that could have on people getting assistance or asking for assistance. People have probably heard that there was lots of discussion in the development of this bill about poll watchers and their authority and their ability to do things. And yes, poll watchers were given more authority to observe more things at the polls. However, there is still a prohibition. A poll watcher may not be in the polling area while a vote is being cast or when an assister is assisting someone to vote. So we think that's important to know about. And finally, there was a provision in this bill that specifically says now that no election official can alter, suspend, change any rule in the election code. So it basically stops the local officials' ability to make any kinds of accommodations or changes in the election law. And the way that things have always worked, well, in lots of cases, the way things work with the voter with a disability needed an accommodation, they would request it from the election official who would then make the determination whether or not to grant this accommodation, because most accommodation requests are for minor kinds of things, going to the front of the line or using an iPad during the voting process, things like that. Well, this provision, we were very concerned, would take away any discretion from local officials to make those kinds of decisions and force everything to become a legal matter that had to go to a court, or at least the Secretary of State. So an amendment was added to SB1 that specifically says that nothing in the election code will prohibit a qualified voter with a disability from requesting a reasonable accommodation or modification to the election process. And this does, I mean, that's federal law now, but this specifically puts it in the code to make sure that everybody is aware that your rights as a voter with a disability to request accommodations have not changed because of SB1. Now that's a lot of information really quickly, but those are the key areas that we think really will impact voters with disabilities.
Thank you, Jeff, for those important details about Senate Bill 1. I appreciate you taking the time because that was a lot. That was a lot of information. And I don't think people with disabilities are aware of all these changes, and it's scary. Now we'll hear from Leah Sifuentes Davis, the Senior Attorney with Disability Rights of Texas. who is going to explain to us some legal action being taken against Senate Bill 1. Welcome, Leah.
Hi, thank you. My name is Leah Sifuentes Davis. I am a 38-year-old Latina, and I have long dark hair and glasses. I have 3 paintings behind me, and I am in an office. Thank you for inviting me today to talk about the litigation surrounding Senate Bill 1. We have filed a lawsuit. We filed in the Western District in the Austin Division. The lawsuit has been transferred, though, to San Antonio. So now it's sitting in the San Antonio Division of the Western District. We are co-counseling this case with the Texas Civil Rights Project, the ACLU of Texas, ACLU National, and the Asian American Legal Defense and Education Fund, as well as a law firm called Jenner and Block. The plaintiffs in the case include Rev Up, but also OCA Greater Houston, the League of Women Voters of Texas, the Texas Organizing Project, and the Workers' Defense Action Fund. We filed the case at the beginning of September, shortly before it was filed by the governor. And we are bringing claims against 2 main provisions of SB1 on the disability angle. The other co-counsel in our case, they are filing claims on Voting Rights Act, the Civil Rights Act, on other issues that will impact the disability community, but are not specific claims under the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. So my discussion will focus on our claims that are under the Americans with Disabilities Act, the ADA, or Section 504 of the Rehabilitation Act, Section 504. The 2 claims that we are bringing are against the provision around the mail-in ballot voter ID. So this is the provision that Jeff talked about that states that you have to provide your ID number on the ballot and also on the envelope in order for your ballot to be counted. As Jeff explained, there are no exceptions to this, which is different than when you vote in person and you have different ways that you may not have to provide your ID. But for mailing ballots, they don't have this exception. You have to either provide the specific types of ID, or there is a provision that you can sign saying you don't have that ID or those types of IDs. But notably, this doesn't include an exception for somebody who doesn't have access to that ID or doesn't know what the ID is. And this may be a large segment of voters with disabilities for various reasons, may not have access to the ID or may not be able to know what the ID is, and thus would not be able to fill it out. Now, what's important about this is that there is if you don't know your ID and you can't include it, then the cure provision that Jeff talked about, in which you may have an opportunity to fix this issue, is unfixable, because if you don't know your ID, you can't know it. That's not how you fix it. And so this presents an issue for somebody who has a disability that doesn't know their ID, maybe by reason of disability, that there's no way for them to fix that. So if somebody calls you and says you didn't include your ID, you don't suddenly learn what your ID is. So there is basically no cure provision for somebody like this. So we brought claims on the voter ID issue based on various violations of the Americans with Disabilities Act. The first is a failure to make a reasonable modification to the policies, practices, or procedures, if that modification is necessary to avoid discrimination against individuals with disabilities. The second is that under the ADA, a public entity cannot coerce, intimidate, threaten, or interfere with any individual in their exercise or enjoyment of, or on account of having aided or encouraged any individual in the exercise or enjoyment of any right granted or protected by the Act. So if they are failing to provide a reasonable modification, then there is an interference with the right to a reasonable modification. So by denying voters with disabilities a reasonable modification to the ID requirement, SB1 interferes with the plaintiff's rights under Title II. In addition, public entities may not impose or apply an eligibility criteria that screens out or tends to screen out people with disabilities from fully and equally enjoying the programs, services, or activities of state and local governments. Voting is included as a service, program, or activity of a state and local government. And because SB1 imposes on voters an eligibility requirement of having and knowing specific ID requirements, the eligibility requirement will screen out voters with disabilities who may not know or have access to those numbers by reason of disability. So we also are bringing a claim, a Title II ADA claim about imposing or applying an eligibility criteria. And finally, the ADA also states that public entities can't utilize criteria or methods of administration. And the term kind of methods of administration here are key, that subject individuals with disabilities to discrimination. And so by using a voter ID criteria that will subject the plaintiff's members in this case and other qualified voters to disabilities to discrimination, they are prohibiting them from being able to vote by mail in the way of voters without disabilities. We also are bringing 504 claims on the same issue, and 504, for those of you who don't know, applies to entities that receive federal funding. So not just state and local governments, but on a totally separate issue, a daycare program, for example, can be an entity that receives federal funding. And so some of you may already know that anytime that you receive federal funding, you're subject to not only the ADA, but also Section 504 of the Rehabilitation Act. And so that's useful information to know, not just in the voting context, but just generally that there may be additional rights that you have under Section 504 if the entity you're dealing with, whether it be a state or local government, or something like a private program that accepts funding in some way through federal programs, they may be subject to 504 as well. So we also have Section 504 complaints in our lawsuit. And then the other provision that we're bringing claims about have to do with the voter assistance provision that Jeff talked about. So this is a notable difference in terms of the change. I want to read to you the provision so we have it very clear about what the change in is. A person who's assisting a voter now has to take an oath. That was already the case, but the way that the oath has written has changed such that it really restricts the type of assistance a person can provide. So the oath says now, I swear or affirm under penalty of perjury, and this under penalty of perjury provision is new, that the voter I am assisting represented to me that they are eligible to receive assistance. I will not suggest by word, sign, or gesture how the voter should vote. I will confine my assistance to reading the ballot to the voter, directing the voter to read the ballot, marking the voter's ballot, or directing the voter to mark the ballot. I will prepare the voter's ballot as the voter directs. I did not pressure or coerce the voter into choosing me to provide assistance. I am not the voter's employer, an agent of the voter's employer, or an officer or agent of the labor union to which the voter belongs. And I will not communicate information about how the voter has voted to another person. And I understand that if assistance is provided to a voter who is not eligible for assistance, the voter's ballot may not be counted. So the key provision here is this restriction of I will confine my assistance to reading the ballot to the voter, directing the voter to read the ballot, marking the voter's ballot, or directing the voter to read the ballot. Previously, it was a wider type of assistance that said you could answer the voter's questions, which is a really key provision that would allow somebody to ask questions. If a voter had questions about the ballot, about what it says, what it means, the assistant that they chose could help them understand the ballot. But now the way that this oath is written under penalty of perjury, there are further restrictions on the type of help that can be provided. And so we are bringing claims on the oath provision because it interferes with the right for a voter to have a reasonable modification. And the reasonable modification is the modification of having an assistant, but it's not giving them the modification that they may need. In addition, there's also a claim about the method of administration here, that they're administering voting with the oath. So the method of administering voting is a method that is discriminating against people with disabilities. There are also other claims, like I mentioned previously, that have not to do with the Americans with Disabilities Act or the Section 504 of the Rehabilitation Act. I think these are useful to understand and know, but I'm not going to go into them with too much detail. I am going to mention, though, that there is a Section 208 claim under the Voting Rights Act, and a Section 208 claim allows somebody to use the assistant of their choice. And so this is something that definitely will, even though it's not an ADA or 504 claim, definitely will impact voters with disabilities. And so it's a claim that we have in a lawsuit as well, that this new assistance provision and the restrictions on it are a violation of Section 208 of the Voting Rights Act that states that you're allowed to have the assistant of your choice. So that's another part of the lawsuit that is, again, impacts people with disabilities, but is not necessarily specific on the ADA or Section 504. So the litigation is relatively recently filed. Litigation typically does take time. So we'll be working on this case in the next months and are hopeful to have a good outcome for communities with disabilities, but also all Texans that are going to be impacted by SB1. Thank you for inviting me, and thank you for allowing me to kind of talk a little bit more about the legal claims of our lawsuit.
Thank you, Leah. Thank you, Jeff. That was important information. That is it for this episode. I want to encourage everyone to like and subscribe so that you can see all our Rev Up episodes on our YouTube channel. Until next time, use your power.